Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. And I know that the last video was uploaded just 5 days ago, but immigration policies are changing rapidly. And in this video, I'm going to share 3 more things that you should know about recent changes to immigration laws. The first change involves filing fees. So in the past, if you filed a case with U.S. Citizenship and Immigration Services, you can combine the form fees with the biometric fees with the same check or with the same cashier's check or money order. However, with the recent change, immigration is now asking individuals to submit separate form fees and biometric fees. So this was an unannounced change with immigration. It wasn't announced on the government's website. However, if you look closely under filing fees, when you click on the applicable form, you will see this new message. Pay each filing fee separately. We are transitioning to electronically processing immigration benefit requests, which requires us to use multiple systems to process your package. Because of this, you must pay each filing fee separately for any form you submit. We may reject your entire package if you submit a single combined payment for multiple forms. So with the new change, remember that if you're filing a new case or an extension of a case, you should make sure that you file the filing fee, you make the check separate, and the biometrics check separate. And the reason why this change is so important is because the government, I recall they did make an announcement related to DACA applications. However, they did mention that it also applies to I-485 green card applications, TPS applications, or naturalization applications. But when you look online and you click under filing fee information, it does have the same exact message. The next major change involves medical exams or immigration physicals. As you know, if you submit an I-485 application to adjust status, usually you can submit the medical exam with your application or at the time of your visa interview. So many times, immigration attorneys will let our clients know that we recommend that you don't submit your medical exam with your application because the interview may take place more than 2 years later. And if that happens and you already gave immigration a medical exam, they're going to ask you to do a new medical exam. And usually medical providers, they'll charge you the same amount as they would as if it was a brand new medical exam. However, recently, the government announced that they would like those medical exams with the I-485 applications. So although it's not 100% required, if you do not submit the medical exams with your green card application, most likely they'll schedule an adjustment of status interview. However, if you submit it with your application, there is a decent chance that they may waive the interview altogether. The reason why I'm making this video and talking about this again, because I did touch upon this on the last video, is because the notices that the government are sending out, they're not all the same. So in our practice alone, we have the large majority of our cases are Houston-based. However, the government is sending out these notices from various immigration offices all across the United States. For example, we have received these notices from the San Antonio, Texas office, the Harlingen office, the Chicago, Illinois office, the Overland Park, Florida office. So there's a lot of different offices that are involved here, and they're all very different. The notices are not the same. So when you look at one and you see that they call it a request for evidence, other ones call it a request for initial evidence, other places call it a courtesy notice, but they're all requesting the same thing, and that's the medical exam. If you receive one of these notices, most likely it's by email. And unfortunately, the government is not copying the attorneys into this email. So if you are represented by an immigration attorney, do not believe the government is copying them to the email. If you receive one of these notices, you should forward that email to your immigration attorney. That way we can tell you and advise you on what you should do. The last major change involves INFOPASS appointments. In one of our prior videos, we made an announcement that if you had a case that involved deportation or removal proceedings, and the immigration court either dismissed or terminated those proceedings, and informed you that you had to make an INFOPASS appointment at your local field office in order to get your green card, a lot of people were having issues scheduling an INFOPASS appointment. because when they would call immigration will let them know that unfortunately we didn't have any InfoPass appointments available due to the surging COVID-19 demands. There weren't enough officers to process those cases. However, the good news is that now it seems like the government is moving forward and allowing people to attend the InfoPass appointments. Now, let me give you a warning about InfoPass appointments. So we had 2 clients scheduled their InfoPass appointments recently, just in the span of the last 7 days, 3 days apart from each other. The first client scheduled the InfoPass on a certain day that I was unavailable. So I provided a packet to this client and I gave it to him and I told him to go and explain to the officer what's going on, give them the packet that we prepared for him, and request that the file from the Texas Service Center be sent to that local field office. That way his green card interview can be scheduled. However, he told me that the officer was very confused and they had issues understanding what he needed. Now, 3 days later, I was back in Houston and I was able to go with the second client for a similar case. In this case, the case was also dismissed by the immigration court, and now the client just needed an appointment at the local field office to get her green card. So in this situation, the officer did give me some pushback, and then I was able to explain to him what the packet was and exactly why the client qualified to have her interview at the Houston field office. And then I was able to sneak in the other InfoPass information from my first client. So again, if you have a case that involves removal or deportation proceedings that was dismissed or terminated, and now you're just waiting for the green card interview at the Houston field office, don't do it yourself. I feel like if you do it yourself without an attorney, they're not going to understand what you need, and they're going to just leave your case there. So again, if you had a case with the immigration court and you're just waiting for the Houston field office to make a decision, I strongly recommend that you hire an immigration attorney to go out there with you at an InfoPass appointment. If you don't, you're going to find that your case is going to be stalled. As you can see, immigration is rapidly changing and evolving. If you're not currently represented by an immigration attorney, it's in your best interest to be represented. That way you stay abreast of all the changes. The government is not going to announce every single change, but they do expect you to know what those changes are. Again, thank you for watching Winning Law. I'm attorney David Nguyen, and we hope that we have made immigration easier to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.